The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Mr. Cox, you may proceed.
Good morning, Your Honors, and may it please Your Honors and the court. Your Honors, I represent the appellant, Ms. Joanne Britt, and Your Honors, the prophet Jeremiah writes, to deny someone justice before the presence of God, to subvert someone in their lawsuit, the Lord does not approve. That is an ancient rule that this court struggles with today, and the rules of this court should not undermine from below or subvert the lawsuit of an appellant. But Rule 4 and Cobbledick versus United States allows the appeal of right, while the current rule creates confusion, disunity of claims, and subversion of due process. My client is a single mom of 4, injured on her job of 15 years with the United States Postal Service, and her only remedy at bar is before Your Honors. Her coworkers, some of which were jealous of her small town position with a special workers' comp claim with limitations, made up ridiculous and petty claims against her, and for cause she was terminated. And then the person who made up those claims took her job. Those are the facts before the court. The district court dismissed with prejudice all 3 counts, except a fraction of the retaliation claim. Now, the problem with that is the court ignored part of the retaliation claim. There was not only a retaliation claim on the EEOC filing, but there was a retaliation claim on the Department of Labor's limitation order. And that was entirely in error, I would argue, ignored by the court below. Cobbledick makes it clear Congress from the beginning has forbid piecemeal disposition on appeal for what practical purposes is a single controversy, set itself against enfeebling judicial administration. Thereby is avoided the obstruction of just claims that would come from permitting harassment and cost of succession of separate appeals from the various rulings to which litigation may give rise from its initiation to the entry of judgment. And to be effective, judicial administration must not be leaden-footed. Its momentum would be arrested by permitting separate reviews of component elements in a unified cause. That's precisely what the court below.
Right. So, Mr. Cox, then should we wait until all of the claims are dismissed with prejudice in order to have a final order, or what would you suggest would be the best approach?
Your Honor, no, the court has issued its final order on the same day it dismissed all claims. It entered a closure of the case, and Your Honor, under Moore's federal practice and the rules of the court, clearly that if a motion to dismiss was sustained, the effect is to dismiss for want of jurisdiction, either the person or the subject matter, or because of improper venue, or for any other reason. Although the dismissal is without prejudice, the judgment is final. And the futility of having to take a fraction of count 3, which in error was even ignored by the court below, so there's no actual ruling on it, in my opinion, except a final order to dismiss it, then that is a futile attempt to amend, while at the same time would create a trap for my client. So, Your Honor, the rules should be much more plain and clear, much like the 6th Circuit, the 11th and 2nd, which has been very clear, Your Honors, in allowing for appeals of right, just as Rule 4 does, which says that once you have that final judgment, which there's no dispute, there's a final judgment of record and a closure of the case before, Your Honors, that the appeal is of right. Now, I think—
So, Mr. Cox, could I clarify?
Yes, Your Honor.
So is your view the district court, by
Judge-
entering that separate, I'm sorry.
Go ahead, Judge.
Sorry, Judge
Hayden.
Niemeyer's muted, I think.
Judge, yeah, you are. You're muted, Judge. Judge Hines, go ahead.
So, Mr. Cox, just really briefly, is your view that separate document the district court entered closing the case satisfies Rule 58, is thus a final judgment, and that your view is that a Rule 58 judgment is sufficient to create finality for an appeal, and that's all we'd actually really have to say in this case?
Yes, as to the final statement, Your Honor. Yes, I would agree with that, except for the final statement that it's not all that Your Honors would have to say, and here's why. What the current rule does before the court to an average plaintiff who has no other option except to come before you is it makes them choose between due process rights. It makes them choose whether or not to take an appeal when they have a pretty much a futile attempt in the district court below to do any kind of amendment because everything was dismissed with prejudice. It bifurcates the claims. They have no unity of case anymore. How can you take a retaliation argument forward when they've denied the underlying discrimination?
Let me ask you this, Mr. Cox.
I'm sorry, Judge.
Earlier, I was trying to ask this question. It seems to me that the statute, section 1291, gives us jurisdiction only from final decisions of the district court. And it seems to me we would normally honor the district court's conclusion that it's a final decision. It may be wrong, but we'd honor it. But it seems to me there is an exception to that, and that's the exception set forth in Rule 54 and in our decision in Porter versus Zook, where the district court does think it's final and closes the case, but it fails to address a claim that still exists in the case. In that case, we said we don't have jurisdiction. Now, it seems to me that's a sensible rule, is to honor what the district court manifests, except in a case where it doesn't decide all the claims of all the parties under Rule 54. Is that what you claim is the existing circumstances here?
Well, Your Honor, I would submit that the problem with that approach does not address the underlying trap that it sets litigants in.
Well, there's no trap. You appeal it if you want. You tell the court to decide it, or you appeal it. But if you appeal it and we have a circumstance where the district court overlooked a claim, then under Porter, as an exception, we don't honor the district court's determination that it's final, and we send it back.
Well, Your Honor, that may be the case in certain cases.
I'm not talking about a particular case where the district court says it's final. In this case, the court concluded that it was entering a final judgment. And normally we would honor that, wouldn't we?
Yes.
Okay, but I'm suggesting that there may be an exception under Porter and Rule 54 where the district court says, I'm closing the case, and the court overlooked an entire count and never ruled on it. In Porter, we said in that circumstance, we don't have jurisdiction. We send it back to the court to complete its job on disposing of the one claim. Now, you seem to be arguing that this case presents a circumstance where the district court failed to adjudicate a claim altogether or a portion of a claim. Is that what you say?
So thank you, Your Honor. And I would say that I think your analysis is correct, except for my.
Well, I want you to answer the factual question first. Is this a case where the district court didn't address a claim that you thought it should have addressed?
So I'm not certain, Your Honor, because I can't get into the mind of our esteemed colleague who ruled on the case, but I can tell you what he ruled. And what he ruled was he dismissed that claim entirely. And he dismissed it as to the EEOC claim expressly, and that was inclusive of two. That count was inclusive of two arguments, two claims, EEOC and Department of Labor. So it's
then if that's the case, if that's the case, then he did not omit addressing a claim. You suggested earlier that he did. If the court addressed all the claims, albeit some erroneously maybe, and all the parties, it seems to me then we're guided by the court's determination that it's nothing further to do. It's not going to do anything more. And it's final. Now, it may not be correct, but the rule says a final decision. And what better, a final order, no, decision. What better do we do than look at the judge's statement when he says it's final?
I think Your Honor is hitting the nail on the head on that, so to speak. I think, Your Honor, the issue, though, before us is a separate, and this is where my client is pleading with Your Honors to consider the underlying merits of her claim that this was dismissed in error. And that's the point that I'm focusing on, the fact that although it is a final order, it was in fact in error, and it needs to be overturned. We're asking Your Honors to reverse and remand because
Counsel,
I think Judge Harris had a question. Judge Wynn.
I'm fine, Judge Gregory. Thank you. I'm fine.
Judge Wynn, go ahead.
I think it's important to look at the state of the law here and then look at what the trial court actually did. There are about 6 cases in a row, others too, that have struggled with this rule. And of course, the seminal one is the Domino Sugar case. That's the case that says that we do this on a case-by-case basis, and then we determine whether the action can be saved by amendment. Then we went to Chow and we said, well, if you stand on your complaint, and here there was no indication in this case of anybody standing on a complaint before the trial court or in the brief until you actually got the oral argument on it. And the question that panel, as I understand, struggle with is, what do we do? We just wait until every time you get there to see if you're standing on your complaint or not. Then the question was whether the court had dismissed the entire action. We went to Penn America on that, and Penn America, we said an otherwise non-final order does not become final even if the trial court dismisses and closes the case. That's Penn America. Then we go to GNC Corporation and we say the plaintiff's election to stand is dispositive. And we're back to that whole question of, did you stand on the case? Good is an interesting case. I sat on that panel, and that's a case in which we sort of bifurcated the whole process, and we looked at the content base, whether it was procedural and not. And then Bain came behind and says, no, that doesn't follow Domino Sugar, and that case should be disregarded. So where we are now on this case, and what the panel confronted in this case was a conundrum. We had a situation where you had 4 claims, 3 of them been dismissed with prejudice, 1 without. The 1 without was a retaliation claim in which we don't know if it could be amended or not. If it could be amended, then it could be cured by amendment, and the trial court set forth maybe 2 different ways it could be done, but none of that came out of the case. So then it comes here, plus it closes the case. But then it comes here, and there's no indication of whether or not the plaintiff is going to stand on, or going to seek an amendment, or stand on the complaint, and that's not indicated to actually get the oral argument, and we're going back and forth, and finally we are here. So the issue that we now face, is there a clearer rule that we can articulate so that judicial economy is served here in the first instance? We don't have to wait to see if you get in other words, it shouldn't be in the hands of the party to determine our jurisdiction. The party shouldn't be able to say in the beginning, well, I'm going to stand on my complaint at the trial, or I'll just wait and put it in the brief, or I'll wait until the court actually have an argument, and then I'll stand in front of 3 judges and say I'll stand on my complaint, and therefore they'll have jurisdiction, which means they didn't have jurisdiction until the party said he had it. And that seems to be a problem. And that's kind of where we are now. And the question is, there are a number of circuits that have gone in different directions. The question is, should we keep this rule and modify it to some degree, or should we get a new rule in line with other circuits that would be a better approach for indicating when this court has jurisdiction on simple matters like this? It's got to help parties like lawyers like you. It's going to help the court, and it's certainly for judicial economy. So that's the issue we confront. It's not just a question of closing the case, because we said in Penn America that's not enough unless there's something else. And then we got to stand on the complaint matter that's in the hands of the parties, and then we got good. And good sort of changes the whole rule. Bing comes back and says, no, good's not good. Well, no pun intended, not good law anymore. So that's where we are in this case. And I think that at least from my perspective, and I think most of the judges, it's not a question of what is better or what's not, or which is. The question is, We need a rule that's understandable and direct that can articulate when a matter is final and when this court has jurisdiction, such as to give the parties clear indication this needs to be appealed, it does not need to be appealed. So what rule would you articulate would fit that definition?
Thank you, Your Honor. And quickly, I would say that you analyzed that well, and I would say it's when any action is dismissed at bar, the Sixth Circuit rule, the 11th and 2nd, all focus on that, and the unfairness and misuse is prevented because they prevent voluntary dismissals from being automatically taken. And so they can't forum shop or transfer jurisdiction. I see my time has expired. May I conclude?
Yeah, you may finish answering their question.
Thank you, Chief Judge. So I think that when you look at the Sixth Circuit's rule, it protects from misuse, while it also provides simplicity to plaintiffs like my client who simply want to be able to have justice. There needs an opportunity for her to have the dismissal reviewed because it was immediately closed, and she's left with the question of, do I try to fight through reopening? Do I try to fight through a partial claim and error and amend? Or can, you know, and now that's disunified, and so now her case is destroyed, and she has to.
Counsel, let me ask you a brief question. Normally, where you have some claims dismissed with prejudice, and some claims or one claim dismissed without prejudice, in that situation, it would be presumptively, the case would be presumptively non-final if there was any claim dismissed without prejudice. But if you take an appeal anyway, when a claim is dismissed without prejudice, aren't you waiving your right to amend the complaint? The district judge said, you've got some problems here. You need to address when the timing of the filing with the EEOC was, and you need to address whether the supervisor was even aware of that, all of which seems to me to bear on any retaliation claim. And if in the face of that, rather than curing the deficiencies that the district court noted, you still wish to take an appeal, but then you can't go back and amend the complaint, can you? If you take the appeal, you've waived the right that the district court gave you to amend, and you're going to stand on the complaint and go with it, whether it's correct or whether it's not. I'm just wondering about a rule where the appeal operates as a waiver of the right to amend.
Well, thank you, Judge. And I think you summarized the current Fourth Circuit approach accurately. And I think that's the problem and the conundrum that I have with my client in that
No. That's the 11th Circuit approach, what was just put up. That is, as I understand what Judge Wilkinson articulated, is by filing the appeal, you then waive amendment. That's the current 11th Circuit approach. That's not our approach.
Well, the relation back, I would stand in correction then. My understanding was that when you have an appeal for any action, including without prejudice, the purpose of that is to seek a reversal. And then I think the Sixth Circuit.
But this leaves you with the option. You can either cure the deficiency in the dismissal without prejudice and then come back to the district court and let the district court decide whether there's some merit to it or whether the district court wishes to dismiss with prejudice, in which case we have a final judgment. So you have the option to amend the complaint. Leave to amend is liberally granted. But if you do not take that option that the district court gave you and you decide to appeal anyway, you may have an appealable issue, but you've also waived the right to amend the complaint, which avoids for us the problem of getting things piecemeal. That's what we don't want. If you don't waive the right to complaint, to amend the complaint, we could decide part of the appeal then it goes back, and you amend the complaint, and then it comes back to us with an amended complaint. And the whole purpose of the final judgment rule is undermined. But it seems to me one possible way to avoid that is to give your client an option. But there are, advantages and disadvantages to either option, but it puts you in the driver's seat.
Mr. Cox, quickly, haven't you already crossed the Rubicon on that? The fact that you appealed here. We're not going to allow you to change the record below here either, right? Haven't you already made that decision?
Well, in this case, Your Honor, that's the current rule before the court, and my client did wish to stand on her complaint as the current rule requests.
Can I ask you a question in this regard?
Yes.
If the district court entered an order dismissing the complaint and giving leave to amend expressly within 30 days, and 30 days comes and goes, and the plaintiff has done nothing, what the status in that situation would be that you would need a further order of court because the court's original order clearly wasn't final. It said you have leave to amend with 30 days. It puts a control in the party, and it makes untenable all the other federal rules that are geared to final judgments. And as a consequence, the Supreme Court, if you know about the Young versus K&D mining, the court said the parties cannot be in control of that. The statute provides that we appeal from a final decisions of the district court. And so the district court enters an order that's not a final decision, but it's conditioned on amending, and the person doesn't amend. And of course, in K&D, they waited 2 years. But the Supreme Court said the district court has to enter another order in view of that delay that makes it final. Now, my question to you, isn't your circumstance fall right within that? In other words, you're suggesting if you stand on your complaint, it becomes final. But that isn't what the district court held. That's what you held. And the putting it in your control now messes up all the rules and the whole structure. And I think it's untenable to have the parties say, I stand on my complaint and therefore it's final judgment. Whether it's a final judgment is up to the district court, whether there's something more to do. So in the case where you say, I stand on my complaint, the Supreme Court would require that then the district court enters another order and saying, okay, the judgment is final. But absent that, putting this in the control of the parties is totally elusive. And I don't think that's a tenable rule, both under the language of the statute and the Supreme Court's decision in K&D. What's your position on that?
Thank you, Your Honor. I fully support and agree with that, because if the judge below had issued an order with a 30-day rule, which actually—
Well, if you agree with that, then I thought you were advocating the fact that you stood on your complaint and it's appealable, therefore. And I'm suggesting you don't have that control under the rules and the statutes.
I'm sorry, Your Honor, I misunderstood. I thought you were looking at what should be rather than what is. And
I'm looking at what the statute, I believe, requires, and it puts the decision-making in the hands of the district court, not the parties. And the order, when a court enters an order that is clearly not final, let's start with that proposition, hypothetically. The court says the court case is dismissed, the plaintiff has 30 days to amend. Now, there's three things that could happen. The party could say, I refuse to amend and stand on my complaint, or he could just simply not act. And so 60 days, 90 days goes by. What's the status of that case? It's no different. In other words, it puts it in the control of the party. And there are dozens of rules and procedures that have to follow from the finality of a judgment. We have the enforcement of judgments, we have appeals, we have Rule 60 motions and all the other things that go with it. So the Supreme Court made clear, and it's worth reading, that when you have a situation where the court entered a non-final decision and the party stands on it, then the court has to enter another order and say, okay, it's now final. And we can then take that appeal.
Well, Your Honor, the only thing that I would add to that is that the current rule that we have to operate with is the one that the Fourth Circuit has issued. And
Well, we're addressing that. That's why we're in bank. We're trying to find out the best rule, the best interpretation. And so let's not go harping on that. We recognize that we have some lack of clarity in our decisions, and that's what we're trying to clarify. So it's important now to find out what is the appropriate interpretation of 1291 and the final judgment rule.
thank you, Your Honor. And Your Honor, I see my time has expired. I appreciate it.
Thank you so much, Mr. Cox.
Thank you.
Court will recognize Mr. Ballinger.
Thank you, Your Honor. May it please the court. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce Ms. Elizabeth Adler, who will be presenting argument for the clinic.
All right, thank you. Ms. Adler, welcome here, court. And Ms. Adler, thank you so much. And it's quite an honor to come from the Academy as a student, and you're here to help us as our friend to what we should do. So please give us some friendly advice. Go ahead.
Thank you, Your Honor. It's a pleasure and an honor to be here, and may it please the court. We think that, on balance, this court got it right nearly 30 years ago in Domino Sugar when it held that dismissals without prejudice are generally not final and appealable unless the grounds of the dismissal make it clear that no amendment could cure the defects. The benefits of this rule were clear. It aligned this court with other circuits, it avoided the need for unproductive additional motions practice in the district court, and it served judicial economy by encouraging plaintiffs to improve their complaints where the circumstances suggested that amendment could cure the district court's concerns. It also protected litigants from a potential trap.
This is Judge Agee. If I could, I'm on the phone, I'm not on the screen. If I could ask a question here. We've tried to utilize Domino Sugar now for some time, and I think as Judge Wynn set out in some detail, it hasn't been as simple as we thought it might be with the long list of cases that we've gone through there. So I'm not sure the Domino Sugar rule without some sort of caveats is going to be any more workable going forward than it has been in the past. But you all have looked at this sort of from an academic perspective. What are the pros and cons, say, of a more simple definitive rule like the 8th, the 1st, and the 2nd Circuits use? So when the complaint is dismissed, unless the court expressly grants the plaintiff leave to amend, that's a final decision. And you can now take your appeal.
Yes, Your Honor, that is the approach that this court rejected in Domino Sugar. While we think that that might be a more efficient rule that reduces motions practice and makes finality easy to determine, we think this court got it right in Domino Sugar. Presuming jurisdiction over all dismissals without prejudice is bad for judicial economy in the long run and creates traps for the unwary. If a plaintiff appeals and unknowingly waives their right to amend, only to be told by the appellate court that it actually would have been more favorable for them to have appealed in the district court, then they're out of luck. As the 7th Circuit put it in
Ballinger, this Judge Diaz here, how can it be a trap for the unwary if we tell the entire world, to the extent that they have interest, that this is the rule going forward? How could that possibly be a trap for the unwary?
Even with such a rule, as the 7th Circuit put it in Otis, litigants without the aid of counsel can forfeit valuable entitlements with such a rule. So it still has the potential to trap unwary or even wary litigants in some situations. So we submit that this court got it right.
That's just a function that's I mean, I appreciate that, but that's a function of, that happens all the time. And that's an unfortunate reality of the world we live in, that not everybody can have the aid of counsel, and we do try to be solicitous to the extent that we can. But Judge Agee's point is that you're asking us to go back to the beginning, a process in Domino Sugar that simply hasn't worked.
We believe that Domino Sugar can be implemented in a clear, bright line way with a few clarifications. So 2 problems.
Can I ask sorry, before you get into that, on this a rule where any dismissal, even without prejudice, is appealable, when does the time to appeal begin to run? And I guess, does that overlap with the time for requesting leave to amend? Are we creating a rule where you have 30 days to request leave to amend, and if the district court doesn't act within 30 days, you've lost your chance to appeal? How does the timing work in the district court under that kind of rule?
Yes, Your Honor, this is why we're encouraging the court to adopt a rule that Rule 58 judgments always create finality. That would line up finality with the notice of appeal deadline, because Rule 58 sets the 30-day notice of appeal deadline and would also make any judgment final. So that's why we think Rule 58 is the simplest way of lining up 1291 with the notice of appeal deadline. And that makes sense because of this court's holding.
I want to dovetail on Judge Diaz's question and Judge Age's question when you support Domino Sugar. Domino Sugar is not the only case we have. We have Chalo that addresses what Judge Niemeyer said is a problem. That is putting it in the hands of the parties as to when they can appeal. Chalo says you can stand on your complaint. Well, when do you do it? Before the trial court, in your brief before this court, or oral argument? You can do all three. And that's a problem. And then you've got the Penn America case that basically says, well, if it's final, the trial's final. That's not necessarily so if there's more that can be done. We walk from there, from the GNC case into the Good case, which really is a conundrum. The Good case really put some serious problems in this circuit. I happen to sit on that panel, but we were trying to make some sense out of this thing. Bing comes back and says, oh, no, Good doesn't work for us anymore. So Domino is not by itself. And I don't think you can speak to Domino and says that's a good rule, because Domino is not just the rule anymore. It has been modified by subsequent case law. So what I think you need to address is the way the law is, not the way we wish it could have been if we just had Domino. I agree. If it was just Domino, we probably could figure out something with it. But we have a lot of cases now that are different. And so to address those concerns, we have other circuits we're not the only one that's struggling with this. But it's a procedural thing. And I think all of us feel this thing needs to be consistent, it needs to be understandable, and needs to confer some notion of when something is final. Someone who's litigating a case, having done that over 30 years ago, I know that's a good feeling, to know that you are making an appeal at the right time and is not going to lapse down the road. And certainly judges want to know that, so that they don't feel like we're at the whims of parties that come to our court and says, okay, well, I'm going to stand on my complaint today, and I haven't said one word about it up until today, which means we didn't even have jurisdiction until it says I'm going to stand on my complaint. So I think you ought to address Domino in light of the case law that has been enacted or set forth in the circuit since Domino. It's not a case by itself.
Your Honor,
Ms. Adler, this is Judge King. I'm on the telephone like Judge Agee was. And I admire the position that you're taking here, planting your feet on Domino Sugar. I see, as Judge Traxler did in Dillon, I think it was in the Bing case, these subsequent cases are outliers. They're one-offs, kind of. They didn't have any power to change Domino Sugar. Domino Sugar is the circuit precedent, and we apply the circuit precedent. Domino Sugar is it. And I think I don't have any reason at this point to see that we ought to be bothering the circuit precedent. If we talk about these other cases, they didn't have any authority or power to modify Domino Sugar.
Yes, Your Honor.
Done as far as
I apologize for interrupting, Your Honor. Please continue.
Can I ask Ms. Adler, let me ask you very quickly this, because Domino Sugar seems to be, I kind of agree with Judge King. That's not a problem. It's pretty clear. We all know what a final judgment is. That's not the issue. I like practical things. It seemed to me, and I can say this, so I won't attribute it to you. I brought it up. But this really is a case that we ought to be talking to the district court judges. And really, we ought to have an opinion and say this, that get rid of without prejudice, because without prejudice should only be used when you believe it's curable. If you believe it's curable, then give them a set time to cure it. But when it comes here, all of them are final. That's what we should do. No more without prejudice. And it's built in, because the only reason you have to do that is that it's curable. If it's curable, do it there. Give them 30 days. If they don't cure it, final, and nothing. So so can you talk to that? Do you think that works? Because I think Domino Sugar is nothing wrong with it. The problem is we get to speak to the people who have control of it, and that's the district court judges.
Yes, Your Honor, we would definitely encourage a rule where this court encourages district courts to, if they really want plaintiffs to amend, to give plaintiffs a set time to amend, and after that time period, enter a Rule 58.
You know, it's not quite as simple as that, though, because when you decide a case on a certain ground without prejudice, it may definitely be final. The motion may be a 12B1, where we're in the wrong venue, or we don't have jurisdiction, or there's a failure to exhaust, and the court issues an order dismissing without prejudice. Those are final orders, unless it can be cured right in the complaint. And so it seems to me it's a more sophisticated problem. And I would suggest that anytime a district court uses dismissal without prejudice, it's an ambiguous order, and that the appellant has the burden of demonstrating jurisdiction, that it is a final order. Absent that, but I suggest it's easy to go and look at why the court dismissed it. Now, if the court dismissed it and said, implied a right to amend, or you can cure it, we would conclude that it's not final. If the court ruled in such a fashion that you could not amend, such as you're in the wrong district, you're in the wrong court, you're whatever, there's hundreds of reasons why you could dismiss without prejudice. The district court does not want to preclude the refiling of an action in state court, say. So he has to do it without prejudice. But we can examine that and find out whether it's final or not. I think the biggest problem is the one that Judge Wynn raised. We just cannot leave it in the control of the attorneys. It's got to be, the 1291 puts it in the control of the district court, and it said we can only hear appeals in final decisions of the district court. And if the district court issues an order that's not final, that means there's nothing more to do. I mean, that there's something more that can be done. Then we don't take it. But it'll be very rare where we don't understand what the without prejudice means. But the Supreme Court has said without prejudice can be final. They specifically held that. And with prejudice, of course, is final too. Now, Rule 54 is the only area that's very clear exception, and that is when the court fails to decide all the claims of all the parties. And that's a black and white rule. And even if the district court says it's final, but it fails to address count 6, we send it back, and nobody takes issue with that. So the rule has to be a little more sophisticated than just taking the rule and say anytime it's without prejudice or anytime it's dismissed, it's final. It just can't be the case.
Absolutely, Your Honor. And that's why we're not advocating for finality turning on whether it's with or without prejudice. My comment to Chief Judge Gregory was merely that we highly encourage this court to encourage district courts when they're dismissing with leave to amend to give that time to amend and have more clarity in that regard.
Of course, and there's so many conditions that can follow. When the court gives leave to amend, implicitly or explicitly, when the court gives leave to amend, it's taking the position the case is not over. The court's decision is not final. And so we can't put it in the hands of the attorneys to determine at some undetermined time when it's final. The whole system won't work in that circumstance. I thought you were advocating a simple rule that anytime there's a dismissal, it's final. And that just simply wouldn't work.
No, Your Honor. We were just encouraging what to do with regards to deadline with time to amend. Our position is that Domino Sugar's rule that dismissals without prejudice are generally not final and appealable can be
let's leave off Domino Sugar. Let's leave off Domino Sugar. What should the rule be now? In other words, we have a rule that says
Judge Wilkinson has a question. Go ahead.
How does Domino Sugar apply in this case? If it's you say that well we should follow Domino Sugar, we essentially got it correct. How does Domino Sugar apply in this case and why?
Because we propose that Domino Sugar should be implemented with 3 clear exceptions and clarifications. So first, where there is a legal defect in the complaint that cannot be cured with an amendment, that should be final and appealable. That was the case in Domino Sugar itself, as well as Young versus Nichols and Go Computer. The second
It's also the exact thing that we try to do in Good. And that's what being criticized Good for. Good try to draw that distinction between procedural and content-based dismissals. That's what Judge Niemeyer is talking about. And that's what's been going on here is that, and that's where Judge Wilkins is going and says, we keep saying Domino Sugar, but it's not just Domino Sugar. Just those approaches have been implemented, and we've been bouncing back and forth. What we need is a definitive rule so that we can know when an appeal is final. And now I will mention Judge Gregory's approach is one that other circuits have lamented, and that is, why don't you put this on the trial judges? Tell us when it's final, or make it final, or whatever, or set whatever time limit you're suggesting. That might be a way to go. I'm only just indicating that is something other circuits have considered.
We think that Good was.
What's your go ahead? You had your first one. You said legal defect, and what was the second and third?
Yes, Your Honor. The second exception would be that Rule 58 judgments are always sufficient for finality. They always create finality. That lines up the finality rules with the deadline for time for notice for appeal. And it makes sense with this court's holding in Labor versus Harvey, where a Rule 58 judgment cuts off the district court's ability to grant a motion to amend a complaint unless the judgment is vacated pursuant to Rules 59E or Rule 60B. So if after a Rule 58 judgment, the plaintiff cannot amend without moving to vacate the judgment, it makes little sense to deny them the right to appeal. So Rule 58 judgments per Federal Rules of Civil Procedure and per this court's holding in Labor versus Harvey should always be sufficient for finality. That's our second rule, our second exception to the general Domino Sugar rule. And it's a clear-cut bright line rule. And it's enough for finality to exist in this case where we submit there was a Rule 58 judgment.
Well, let me ask you this problem. We have a statute that says explicitly that a judgment must determine all the claims and all the parties. That's Rule 54. And we have cases, and the Supreme Court has cases, when you don't decide all the claims, it's not a final judgment. So a district court dismisses counts 1 and 2 and forgets all about count 3. And it enters a judgment under, a paper under Rule 58. That is not a final judgment, even though it purports to be. And that has been said by almost every court. I think it's been said by the Supreme Court, but it's said by statute. So I don't think we can get simple rules. I think that we start off with 1292, and we say, what is a final judgment? That means there's nothing further to be done, and we focus on the district court's order to determine that. And then we can give specific rules for different occasions. Every 12B1 and 12B2 dismissal without prejudice is still a final judgment, right? Unless the court explicitly says you can cure it. I mean, we're not going to be able to come up with a silver bullet that's going to take care of everything, but we can come up and eliminate some of the problems we've created in some of our cases by going back to the statute and going back to the rule and laying it out. You're trying to find some specific exceptions, like every time there's a Rule 58 paper filed, it makes it a final judgment. But nothing in the statute says that. That's necessary for a judgment, but it's not sufficient.
Your Honor,
I'm not sure Ms. Adler got to her third exception, and I just want to understand the entirety of what she's suggesting. So Domino Sugar, the 2 exceptions, and then there's a third, Ms. Adler?
Yes, Judge Thacker, thank you so much. And of course, I see my time has expired and in fact has for several minutes now. May I have leave to give the third exception and then finish answering your question?
Absolutely.
Thank you so much. The third exception is, of course, allowing finality where the plaintiff has elected to stand on their complaint and is waiving their right to amend in doing so. Now, this is a rule that this court has recognized in several cases, Chow, Bing, INRI, GNC, and in fact, Good. And we think that Good was correctly decided in the sense that Good did not allow the plaintiff in that case to stand on their complaint because the plaintiff was unwilling to waive their right to amend. Plaintiff should only—
the Good case that Bing expressly says is not consistent with Domino Sugar?
We read it differently. And we think that because Good focused so strongly on whether the plaintiff was willing to waive their right to amend, that's vitally important to the standing on their complaint rule, because that when plaintiffs elect to waive their right to amend, that solves the Domino Sugar Court's concerns about repeated interlocutory appeals. Waiver solves
Ms. Adler,
that.
can I ask you, with respect to that exception, when do you propose that a plaintiff's right to stand on his or her complaint would end? I mean, at some point it's got to be cut off, right? So when is that?
We think that an ideal rule would probably require it in the statement of jurisdiction in the briefs. However, we understand that that didn't happen here and hasn't happened in some of the court's cases. It's happened at oral argument. So we agree with the Appellee's brief that it can happen in the statement of jurisdiction in the brief or at oral argument, but we understand a preference for the former.
One thing I was intrigued by was Judge Gregory's suggestion that district courts give us some clearer signals. Part of the problem with this case is that there was a dismissal without prejudice, and the defects in the complaint were noted, but at the same time, the district court said to close the case. And so you have all this ambiguity. So it would help us a lot. And I think Judge Gregory is right on this point, that it would help us a lot if district courts were just clear about when a judgment is final. And there are a number of ways they can achieve that clarity, and maybe we should set that out for them. But we need more help from district courts on this. It's not just a matter of us trying to figure out what the district court meant or what it said. It's up to the district court to provide a greater measure of clarity as to finality. And there are probably several ways of doing it. But we are kind of asking district courts to change long ingrained habits, because there's a certain amount of vagueness and ambiguity in this whole area. And maybe it would profit from just a suggestion on the part of the Court of Appeals to, would you please say when you think a judgment is final and when it's not? And here are various ways you can indicate that a judgment is final and appealable. And maybe that's part of the way to go, but I do think that the Chief is right, and that one of the missing ingredients here has been clarity on the part of the district court. And this case exemplifies it, because there were things that were done that could point in both directions, that it was not final, but that it was final. And so the litigants are left with that, and we're left with that. But maybe that's a clue to unraveling this whole thing.
2 points in response, Your Honor. We think that while we understand the appeal of a rule that puts it to the district courts, the Supreme Court's holding in Malice seems to reject the idea that we should just send plaintiffs back to the district court to get some sort of final order or Rule 58 judgment. That would be wheels spinning for no practical purpose, in the words of the Supreme Court. So while we definitely encourage more clarity on the part of the district courts, we don't necessarily encourage a rule that's—
No, I'm thinking about clarity ab initio. I'm not thinking about clarity after a remand. Okay, I'm thinking about clarity ab initio.
Understood, Your Honor. And to your point about where the district court's order looks both ways, we think that it's better to treat those orders as final. As Judge Easterbrook wrote in the Seventh Circuit case Hoskins, courts lay a trap for unwary or even wary litigants who may forego appeal in reliance on without prejudice language, only to learn that that original order was final and appealable, and to their horror that appellate jurisdiction and the time for appellate review has lapsed. So we think it's better to err on the side of finality than not in the case of a.
I worry that these three exceptions are going to continue, particularly the third exception, are going to continue to leave us in the big muddy. And that's the problem that we've had. And I'm just not sure that a domino sugar rule with three exceptions, which erode the rule, particularly the third one, I'm just not sure that extricates us from the difficulties that we've been facing. I have a really made up my own mind on this, but that's a concern I have.
Yes, Your Honor. Well, I see my time has expired. And so we encourage this court to adopt a rule that makes finality easier to determine and does not lay a trap for unwary litigants. Thank you so much.
Thank you, Ms.
I just want to be clear. I just want to be clear on that the rule that Judge Wilkerson articulated is essentially the Second Circuit rule. And that is the rule that a dismissal without prejudice does not, and this puts the onus on the district court, does not give leave for amendment and close the case is final. That's essentially the rule that on the Second Circuit.
Thank you, Ms. Adler. Ms. Cox?
May it please the court, Rebecca Cook on behalf of Appellate. The issue of when a dismissal without prejudice under Rule 12b-6 is final and thus appealable is not resolved by a one-size-fits-all bright line approach. That's because, as this court recognized in Domino Sugar over 3 decades ago, dismissals without prejudice usually are ambiguous and require further analysis to determine whether the district court intended its order to end the case. The Supreme Court has not clearly specified an approach to without prejudice dismissals with respect to 12b-6, but the Supreme Court instructed in Mohawk Industries v. Carpenter that finality under under 1291 should be given a practical rather than a technical construction. Given the complexity of without prejudice dismissals under Rule 12b-6, a universal approach has not evolved across the circuits. And as we've discussed this morning, courts of appeal continue to grapple with how to craft the most straightforward and easily administered approach consistent with the objectives of 1291.
Counsel, can I ask, why don't you think that the Supreme Court's decision in Wallace and Tiernan, why didn't it set out the rule? I mean, I get that we haven't followed it in Domino Sugar or otherwise, but the court there said dismissal without prejudice does not make it unappealable because that ends the case as far as the district court was concerned. That seems to adopt a pretty bright line rule. I mean, that's the one Judge Wynn just said, I think is the Second Circuit, maybe. Right? That's the Supreme Court's statement on it, right? And that seems like to be a pretty clear rule, right? It doesn't turn on a case or a complaint or, it doesn't turn on an election or any of those things, right? The Supreme Court just says dismissal without prejudice ends the matter below, and that's appealable.
I'm sorry to interrupt. A dismissal without prejudice, that is a bright line of rule that would actually contravene the purposes behind the final judgment rule. We don't want to craft a rule that you can appeal from every single without prejudice dismissal. Because the concern there is you're going to get a plaintiff with multiple bites at the apple. We don't want to see an appeal on the without prejudice dismissal and then a further appeal after remand on an amended complaint that gives.
But why isn't that just a question about what the standard is for granting a leave to amend after appeal? And that we have cases on that issue too. Right. And there's maybe some circumstance in which it could be granted. It seems to be a pretty narrow set. Maybe it could happen. Right. But that's the whole nature of dismissal without prejudice, that it could come back up again. Right. That's why it's without prejudice. And whether it's in a amended complaint in some unusual circumstance or it's in a new action, right, it's not final in some for all time philosophical sense, right? It's final for this action as it stands. And that's what Wallace and Tiernan tells us. And maybe the policy cuts a different way, but I don't see why Wallace doesn't sort of resolve that.
Well, you get the purpose of the final judgment rules, you get one appeal, you get one shot. And we don't want to craft a test that undermines that core purpose of 1291. If you have a rule where you are going to appeal a without prejudice dismissal, it needs to be with the waiver of the right to amend in the future that protects against two bites at the apple and preserves finality.
What's wrong with requiring the district court, if the district court doesn't want it to be final, the district court can add language saying granting leave to amend. But in the absence of granting leave to amend, the district court can be told that its orders without prejudice, dismissals without prejudice, are final orders. And unless the court determines it wants to keep the matter and do more with it. I mean, the whole thing is whether the district court thinks it's over or not. And if it just simply says, Judge Richardson's proposal makes a lot of sense and put the burden on the district court.
And other circuits have tried. For example, we have the Third Circuit admonishing district courts, and you see back in Borelli v. City of Reading, 532 F. 2nd 950. That was back in 1976, and then most recently in Weber v. McGrogan, 939 F. 3rd 232. That's 2019. You have the Third Circuit admonishing its district courts on best practices with respect to without prejudice dismissals with Rule 12b-6. You have the Third Circuit repeatedly providing guidance to the district court on what to do without prejudice dismissals, and to please provide a window to amend. Please include in your order that if there is not an amendment within that period, a final judgment will be issued at that point, and also include in your orders that if the plaintiff doesn't want to amend, the plaintiff should file a notice of stating their intent to decline amendment, and that they are going to waive right to amendment. And then at that time, the district court would issue a final order. The Third Circuit has repeatedly put that admonishment in its decisions. The problem is when it doesn't get heated. And the Third Circuit is still grappling with, what to do when you have a situation similar to this case without prejudice dismissal. The case is closed, but you also have to keep in mind that the plaintiff is the master of their complaint. The plaintiff is free to decline the invitation to amend their complaint. And in a perfect world, the plaintiff would make that statement of their intent in the district court. But in practice, that does not always happen.
Counsel, I get that, there are a lot of times when people, when the district courts are not as clear, and, it'd be great when they're clear, and, it's kind of easy to say that, but it's tough with the caseloads they have, and they have situations where there's pro se plaintiffs, and, they've given opportunities to amend, and, they really are hesitant to have a order that has res judicata effects. But, despite efforts, there's no valid complaint. And so it seems to me dismissals without prejudice, serve a valid purpose, not just for the required situations like Judge Niemeyer mentioned, but in the situations I just described. And with that in mind, why isn't an order that dismisses all the claims, even if some are with prejudice, that leaves the district court with nothing else to do? In other words, there's not been any leave granted. Why can't we consider that final? I just don't see I don't really see what the harm is. The plaintiff then knows when to appeal and when not to appeal. And we have clarity, and it seems like the only risks, would be that maybe there's some situation that's kind of, to me, hard to fathom, that we might occasionally have to address with something after an appellate decision, but it seems like that's pretty rare. And the only other risk I can really think of is, well, does an unwary plaintiff statute run? But, you can only do so much to protect that risk. And I'm worried that what we may end up doing is incenting district court judges to dismiss cases with prejudice when they want to not create that res judicata effect. So that's a lot of talking, but I'm just back to the question of what's wrong with an order being final if, even if some of the claims are dismissed with prejudice, if there's no grant of relief to amend?
Well, I think we don't want to lose sight of the central holding of Domino Sugar, which is
we're trying to decide. I'm sorry to interrupt you, but maybe this is what you're going to say. I mean, the whole purpose of being here is to look at this without constraints of our prior cases. That's why we all got together. So, I mean, if you want to say Domino Sugar is the best rule, by all means do it. But we're here so that we can decide whether or not to keep Domino Sugar. So we're willing to say Domino Sugar is wrong or what Domino Sugar is right. I'm just trying to say, why isn't the rule that Judge Richardson articulated, what's the problem with that?
You still want to understand what the district court's intent was. So you still need to review the district court's order and its memorandum of opinion to fully appreciate whether or not you have a manifestation that the district court was done with the case. You know, for example, in this case,
that's an idealistic approach, and what we're trying to address is when the district court fails to make that manifest. And so we need some default rule. And the notion is, if we start with a default rule that when a case is dismissed with or without prejudice, without further instruction, then we start with the proposition that the dismissal ends that complaint, ends the case, and it's appealable. And whether it's without prejudice, the reason for the without prejudice can be that they can file, and they don't want, the court didn't want res judicata apply, but that could be for a lot of reasons. And the notion that we start with the proposition that unless the district court indicates it wants something more to do in the case or expects something more in the case, that we presume that when it dismisses a complaint, it's final. Except Rule 54. You have to always cover Rule 54, which is a separate statute.
I mean, at least with respect to 12b-6, dismissals without prejudice, it's potentially problematic because as you don't want to afford the plaintiff multiple bites at the apple. That is not what is contemplated, and that undermines the purposes of 1291. And so you need to look at the manifestation of the district court's intent, and it is still a good rule to allow the plaintiff to stand on his or her complaint.
What's wrong with putting the burden on both the court and the party to take the case further? The judge reviews the complaint and says it fails to state a plausible claim and dismisses it and says nothing more. At that point, either the court or the party can say, well, can we amend or file a motion to amend or whatever. But if they just leave it alone, it's appealable.
Well, then that raises several questions. Well, how long do you wait? What if there
30
is
days? They have 30 days to appeal.
You have 30 days to appeal, and in that 30 days, are you also expecting the plaintiff to file a notice of their seeking to amend the complaint?
Under that rule, both the plaintiff and the court know that it's final and appealable because we would say so. And so if they want to avoid that ruling, they would have to take some action. Either the court saying you have leave to amend or the plaintiff asking leave to amend. But it seems to me to guess that the court might want to leave to amend or the plaintiff might want to leave to amend is too amorphous. And we're implying finality.
Well, to impose those sort of requirements, we do want to steer clear of a hyper-technical interpretation of 1291. You know, the goal is a practical interpretation of 1291. And we don't want a situation where the plaintiff has multiple opportunities at an appeal. And that could be the likely path of the test that you're proposing. And I do want to go back to, this stand on the complaint doctrine and Judge Wynn's concern as to when that should be expressed. And ideally, it should be expressed in the district court level, but oftentimes in practice that does not happen. And you see other circuits that getting that statement made in the briefing, or sometimes it's made in the oral argument, or even sometimes it's made in supplemental briefing. But there are ways to move that statement earlier and get a clear expression of plaintiff's intent earlier. Amicus has suggested putting in the jurisdictional statement. Well, you could even move that earlier and put it in the docketing statement. The docketing statement already addresses has pre-printed forms relating to jurisdiction. You could easily add a question in there with respect to a without prejudice dismissal under Rule 12b-6. Do you intend to stand on your current complaint and waive any right to future amendment? Yes or no? A binary question like that gets a very clear expression of the plaintiff appellant's intent. And if you do get a no, well, then you either invite from the appellee an objection or a motion to dismiss for lack of jurisdiction, or the court could review that docketing statement and issue a show cause order. You also have in other circuits have staff that review new appeals that are coming in and review the district court orders for without prejudice dismissals. And in some of those cases, those circuits issue show cause orders right out of the gate to front this jurisdictional issue and to confirm.
That whole scenario goes back to the original point that Judge Wynn pointed out by putting this in the control of the parties. The district court enters an order to dismiss without prejudice and grants leave to amend. That order, everybody concludes, including the Supreme Court, is not final. The court has left something further to do. So all of a sudden, we have a non-final order under 1292B, which is not appealable. Now, what you would propose is that the party can make that order final. And he can't make it final. He's not the court. Or the plaintiff is not the court. The plaintiff just imposes a condition and said, I propose to stand on my complaint. That doesn't make the court's order final. It was not final. So the court would have, if the plaintiff wants to stand on his complaint and challenge that ruling, it's going to have to take whatever steps are to get a final order from the court. And that's what the Supreme Court in Young versus K&D said explicitly. You have to get that second order.
And you would want that to happen in the district court. In some ways, it does exalt form over substance.
No, it's a question of who enters the order. You're suggesting that a non-final order can be made final by a party.
And some courts, some other courts of appeal do follow that approach, that even in those situations where the district court entered a without prejudice dismissal and the plaintiff decides to appeal before that window of time to amend has expired, that is still a final judgment. And they have not kicked it for a lack of jurisdiction, because the plaintiff is the master of their complaint and they do have the ability to.
Yeah, but the plaintiff is not the master of the court's order. And if the court intended to end their non-final order, that's the court's decision. And the court can enter a final order, but the party can't.
And I don't dispute that.
That's what you're arguing, though. You're suggesting that the party is going to convert a non-final order into a final order by taking a position.
Well, and in some ways, I think we're trying to figure out a mechanism to get there. Because if the plaintiff is going to decline the invitation to amend, there is no process contemplated in the civil rules of procedure for that party to do that. And in some cases, you have the district court.
I'm sorry, Judge Harris.
Sorry, I just have a really quick question. I think at least in the 11th Circuit, the rule is just that the order becomes final when the time given to amend expires. If the judge says you have 30 days to amend, 30 days go by, no one has done anything, now it's a final order. Would that not work? I mean, I understand a plaintiff might want to start the appeal on day 25 rather than day 30, but it's not a significant burden to just have to wait until the time runs out, is it?
It's not a significant burden to wait until the time runs out. The rule obviously needs to be clear, and you still want to prevent against the situation where you have multiple appeals. So you still want an express statement from the plaintiff that they understand that they're not going to get another bite at the apple. In this situation you just articulated, obviously the plaintiff has, that window of time has expired. They declined the district court's invitation to amend. They want to appeal. I think I guess in that particular situation, it's a further statement from the plaintiff would not be necessary because you would infer that from their inaction of filing an amendment during the window granted by the district court.
But you still are giving the final decision, as Judge Niemeyer pointed out and emphasized, you're assigning the district court's authority to the lawyers, and you can't do that. The 1291 says you have to have a final decision of the district court, period. That's the statute. That's where we have to start. And as Judge Gregory said, maybe that's the way we resolve this whole thing, by getting the district judges to understand what the Domino Sugar case said.
And I'm out of time. May I respond?
Yes, you may, Ms. Cope.
Thank you. And I agree with that. And the issue arises is when you have situations like here, where you have a without prejudice dismissal, but then you also have a order that's closing the case, and there's no window granted to the plaintiff to amend. It's a little murky, and next steps are muddled. But as long as you have the doctrine where the plaintiff can stand on their complaints, it moves this forward and preserves the objectives of finality.
So you, in essence, articulating the 11th Circuit rule. 11th Circuit rule basically allows a dismissal without prejudice if the trial court, in fact, indicates leave to amend and gives a time for that amendment to occur. It then says the plaintiff can, and maybe this is a nuance to what Judge Niemeyer may satisfy, he can take matters in hand. If he files the appeal, it then waives it. So that's the end of it. It cuts off that choice. By filing it, you basically says, no, you don't have that, you can't amend it anymore. So that's the 11th Circuit rule. And that every one of these rules, there have been some problems articulated in it, but that's the rule that they have. Is that
right.
What you favor?
No, and one of the downside to the 11th Circuit rule is that for the plaintiff who is in a rush to file that notice of appeal, they may not fully appreciate the consequences of their actions. You want to make sure that the plaintiff fully appreciates that when they file that notice of appeal, they have waived their right to amend. I mean,
Once they have noticed, there's only so much we can look out for plaintiffs, whether the pro se or whatever. You file that notice, this rule is articulated, and it's not like we made it up. You now know there are a lot of rules like that. If you miss a statute of limitations, that's terrible that you missed it, but that's the rule. And so the question is, what we're trying to do is get some clarity in a rule, as Judge Richardson and Judge Qualibon's articulated from the Supreme Court, and that case has somewhat been nuanced by these other circuits, but that's the object of it, is to get some clarity here of when it's going to occur. And yeah, there'll be times when the plaintiff may not quite fully appreciate it, might know it, but at least you know what the rule is. If you file that complaint, you don't have any more a right to amend. That's what the 11th Circuit says. What's wrong with that?
Well, I think you lose some of the benefits that you get from Domino Sugar. You lose the benefit of looking at the district court's order and an opinion for the manifestation of the district court's intent.
Well, Judge Qualibon made it clear. We're here on a clear slate. And yeah, you lose some benefits, but the cost of losing those benefits is outweighed by the additional benefit you get of knowing something, and
Judge
this
Rushing?
court having some idea of it.
Judge Rushing?
Can I ask about the time for filing the notice of appeal in this sort of 11th Circuit situation where, we've talked about, a plaintiff who knows they want to appeal, they could go ahead and appeal during the time that they have to amend if they want, and they've cut off their right to amend. What about the plaintiff who waits until say they've been given 20 days to amend, that time expires? And do we expect them to know at that point, now you have 30 days to file your appeal? They look at the rules that say you have 30 days from, the final judgment. Are we expecting them to know that, well, when you decide not to appeal, that becomes a final judgment, even though the district court hasn't done anything else in your case, and now your time to appeal is running? Is that, maybe we can say we set that rule and everybody's expected to know it, and if you don't know it, it's too bad. But is that the way the 11th Circuit does it?
I don't know the answer to that with respect to the 11th Circuit. I do think that would be a problematic result. Because it's unclear, right? If you have that 30-day window to amend, to your point, does the time period start once on day 31, or do you wait and expect the district court to issue a further order converting that without prejudice dismissal to a with prejudice dismissal, and then your window of time to appeal starts from that further order?
The problem is, under your proposal, or even under the 11th Circuit proposal, the time for appeal runs from a district court order, 30 days from the order. So the district court enters a non-final order giving leave to amend, and the plaintiff on day 25 says, I'm standing on my complaint. And then nothing happens for a while, and assumes that when he or she filed that on day 25, filed that is the final judgment. And so now she or he has 30 days from then to file an appeal. But of course, the statute says 30 days runs from the judgment, not when the person makes an election. What do you do then?
You would still go back to you would have to go back to the district court order.
Yeah, and which was non-final.
But no, I guess I'm not following that concern, right? Because Federal Rule of Appellate Procedure 4A7 tells us when the judgment is, and the judgment's not the order, the judgment is the judgment, right? And the final order is not the final judgment. So the time to appeal begins to run based on Rule 4A7, right? And so I don't even understand why there's a problem.
So in that instance, the final judgment is when the time expires. Like on day, you're given 20 days to amend. On day 21, that is a final judgment all of a sudden, even though there's nothing new entered in the case. That's my question.
Well, so I don't mean to answer, but I thought the answer with that would be is that we look to 4A7, and that says a judgment is entered for purposes of notice of appeal, there are two different sets, and it depends on what kind of an order it is. But like seems to me we look to 4A7, and that's just a different question about whether the order itself is fine.
The problem with that is
my point in asking this question, counsel, is
Rule 4 tries to address all the orders that are appealable, including injunctions and all the other things, whereas 1291 is the statutory authority, and 1291 says from the final decision of the district court is the time for appeal, and it says it's jurisdictional.
My point in asking this question, counsel, is obviously the question of whether we have jurisdiction under 1291 is different from the question of interpreting the rules, but these two are related. And so when we say that something has become final and we have jurisdiction, we have to be thinking about what are the consequences down the road that we're going to be facing when we have to make decisions about, well, when did the time start to run? Was the plaintiff aware? these sorts of questions that they may or may not be complicated in these different scenarios that we're thinking about, but it's an implication of the decision that we make today.
And Judge Washington, your concern is exactly what the 11th Circuit has grappled with that rule.
Anything else, Ms. Koch?
I would just like to conclude that it is, to be clear, we would still advocate for this court's current approach of Domino Sugar and Chow and NRA GNC, but I do think there are administrative changes that could be made that would iron out some of the confusion that can arise in these sorts of situations. Whether, as I articulated, that's a change to the docketing statement, whether it's a adoption of a court rule with respect to obtaining statements of the plaintiff's intent to stand on their complaint. I do think that there's some administrative changes that could be made, in addition to admonishing district courts on the steps to be taken and the language to be included in their orders with respect to without prejudice dismissals under Rule 12b-6. Thank you.
Thank you, Ms. Koch. Mr. Cox, you have 5 minutes of reply time.
Thank you, Chief Judge. Thank you, Your Honors. Your Honors, I would argue that what Judge Richardson and Niemeyer and others have pointed out, that Tiernan focuses clearly, as well as Rule 4, on the right to appeal. It does not limit it to with prejudice. And it can't be more clear of a line that would be helpful.
But is Tiernan that clear? The court in Tiernan wasn't really setting out a rule for all cases. In that case, the district court denied a government's motion for production of documents that were essential to proving the government's case. And then the district court said judgment may be entered, dismissing the action with prejudice. So that's very clear, right? There's a judgment, it's dismissing the entire action. The documents were essential to proving the case. So I don't know that that necessarily resolves the more ambiguous question about other cases where only one count is dismissed without prejudice. Do you think Tiernan sets out a rule that all without prejudice dismissals are in fact final and leave nothing for the district court to do?
Well, thank you, Your Honor. It says, and I'm quoting, that the dismissal was without prejudice to filing another suit does not make the cause unappealable. For denial of relief and dismissal of the case ended the suit so far as the district court was concerned. So at least as to when cases are dismissed and closed, as in the instant case, I would argue that it's a very bright line that should be adopted by the Fourth Circuit. I would also say that it shouldn't preclude a plaintiff. There's no multiple bites at the apple when, as Judge Richardson pointed out, that without prejudice just should mean that it should not prejudice a plaintiff who has to resolve the fact that their case has now been bifurcated. They need to get the case reunified, and they shouldn't be prevented from doing that through the appellate process. I think that that's exactly what the Fourth Circuit rule leads to, unfortunately, in many cases. And I think that's the downside to the way the 11th Circuit applies this. I think that judicial economy should not be the focus, Your Honors. The focus of the rule should be to provide the next. Yes,
you could ask for a final judgment. You could go right back in and ask for a final judgment when you get one of these orders. Lawyers know how to make motions for entry of a final judgment, period. And the district courts know how to enter final judgment.
Your Honor, I would argue respectfully that I would have to file a motion to reopen the case first because the case was closed at the time of the dismissal. Now that's a procedural question. I'd have to research that more in depth, but it was certainly indicative of the concern of the way the rule plays out. And I think it tends to focus instead of on advancing the cause of justice for plaintiffs who have legitimate cases, it tends to focus instead on limiting their options and making them choose between a rock and a hard place, choose between whether to keep fighting on with multiple motions to reopen cases, to try to amend, or to try to reunify their case and have that option to go forward with a proper approach that allows for all the evidence, as in Judge Rushing's point with the Tiernan case. The material evidence in this case is the discrimination. How can we proceed on a bifurcated claim with limitations on that? And that's why we're asking your honors to reverse and remand, vacate the judgment below, and provide opportunity for my client to pursue that justice, to have that opportunity that every American plaintiff should have. And I thank you, Your Honor, for the time today. It's a great honor to appear before you en banc, and I wish you the best and happy New Year.
Thank you, Mr. Cox. I also want to thank Ms. Koch and Ms. Adler. Adler, you acquitted Mr. Jefferson's school very well today. Thank you so much for being here. And all of you, we would love to come down and shake your hands, but we cannot under the circumstances we all know that exist. But know very much that we appreciate your help on these very complex matters, and we thank you so much, and we wish you well. With that, I will ask the Deputy Clerk to adjourn the court. Sine die.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.